Hey guys, Sam here with Wooden HS Social Studies Honor Society. I'm here doing a review of Unit 4 AP NSL Vocabulary Key Terms. And right now I am midway through the judiciary section of this unit. So, starting with civil law, it's a dispute between two parties. More evidence favors plaintiff than the defendant, usually involving wrongful acts like negligence, slander. So then you're paying damages. Criminal law, individual conduct, protection of property, safety, infraction of law. So felonies, misdemeanors, petty offenses. And then the burden of proof is you need sufficient evidence. Litigation brings something to court as a form of trying to get something done or proven, like NAACP and Brown v. Board of Education. Litigants are groups that take over for the defendant or prosecution to help further the case, like the NAACP. Class action lawsuit, group of many people under one name to file a lawsuit. Precedents, previous case outcomes and set the example. Stare decisis, previous decisions that help in deciding new cases. Majority opinion, the majority of the justices vote this way, and the rationale stands as the decision. Dissenting opinion is not the majority, is disagreeing with the decision and rationale. Concurring opinion is agreeing with the majority but under a different rationale. Seriatim opinions, each judge has a separate opinion. Excuse me. Per curiam decision. Per curiam. Curiam. That's how you say that. Alright, words. Majority, concurring, dissenting opinions. It's just the different opinions. Writ of mandamus or mandamus. Supreme Court decision that forces Congress and President into action, unconstitutional. Habeas corpus must be held for court with reasonable evidence. Strict construction versus loose construction. Interpret the framer's intentions or more broadly, and stand by framer's original intentions. Framer's intent for the judiciary, weakest and least threatening branch. Court packing plan is increasing the size of the Supreme Court to rule in favor of legislation, FDR and the New Deal. John Marshall was the co-equal branch of government, no more separate opinions of authority and prestige, judicial review, the Supremacy Clause. So those are some things he did. Roger Taney, Dred Scott decision, slaves aren't citizens. Earl Warren, expanded rights of criminal defendants and racial and religious minorities. Ideology of the court, conservative, liberal, neutral, moderate. More neutral means moderate. More conservatives. Right now, there's more conservatives right now, I think. Current Chief Justice John Roberts Jr. Current ideological makeup of the court is 4 conservative, 4 liberal, and 1 moderate. And that concludes the judiciary. Thank you for listening. Next episode, I will work on Unit 6. Unit 6, I cannot speak today, which is the Civil Rights and Civil Liberties Unit. So that's a bunch of court cases that I'll be going over.